Hello, Colleen Drum with SFM's Claims Technical Team, who assist our claims representatives by doing training, research, file reviews, system enhancements, and provide overall support to our claim reps and their business units with the work that they do. What I'm going to talk about next is what happens when a workers' compensation claim is filed with SFM and some of the aspects of claims handling. First of all, what is a work-related motor vehicle accident? If an employee is involved in an accident while commuting to work at the normal everyday job site, those claims are generally not covered, and that is what your auto insurance is for. However, if an employee is sent out on an errand, for example, picking up supplies or going to or coming back from a special work event, these are generally covered by workers' compensation, as well as employees who travel from portal to portal for work. For example, a home health care worker who is serving clients all day in their homes. But an employee who is driving home from a work-related event who deviates from that route to go visit a friend for a happy hour or two is not in the course and scope of their employment if an accident occurs. Workers' compensation is a no-fault system, and we do cover employees' negligence if they are at fault in a work-related accident, but having safe driving policies and showing a pattern of following and enforcing your safety protocols with the rules of the road is important. So if an employee who is ticketed for distracted driving while texting reports that he has also witnessed his own supervisor not following the employer's hands-free cell phone policy, then it does not appear to be a truly prohibited act, as there is no consistency, enforcement, or consequences despite the employees signing off to be in compliance with a handbook policy. Once you've been made aware of a potential work-related accident, we have a variety of ways to report the claim. The most convenient is to call SFM's injury hotline and speak with a representative to report the details. SFM will create the first report of injury form, also known as a FROI, and you and your employee will be sent a copy. You can also report your claim online at our website, which also has a ton of other employer resources available to reference. Or fill out your own FROI and email it to SFM or fax it. If an accident happens, it is always best to report it as soon as possible, even if you are unsure of coverage. Go ahead and report it so SFM can investigate and make that determination on compensability. As the employer, you are one of the first to hear about an accident, so gather as many details as possible to provide to SFM. Don't delay in filing the report for any missing information. Just continue to gather the facts from the parties involved and communicate to your claims representative as you receive updated information. Here's an example of a FROI from Minnesota, but all jurisdictions are similar in what the state requires in reporting. So here, it appears that the employee, Superman's alter ego, Clark Kent, was involved in a work-related motor vehicle accident on May 21st, 2024. All pertinent information about your employee is needed, including social security number, date of hire, phone number, address, etc. The employer, Drivers R Us, has filled out a very detailed accident description. Employee was in a company truck making a special wicket delivery to a customer and was rear-ended on Highway 494, merging onto Highway 35W North. Police were called to the scene, and we see that the employee was taken by ambulance to Hospital Friendly and was admitted for treatment. It appears to be a fairly significant event with injuries to his head, neck, back, and chest. Passenger Pigeon is also a witness to the accident for a statement if needed. We have Big Boss as our employer contact at Drivers R Us to confirm details, get any status updates, the police report, medical paperwork, and employee's payroll history, as we can see that he is now losing time from work. It is also the employer's opportunity to ask questions and make us aware of any concerns about the reported accident or the involved employee. I once had an injury claimed for a bus driver who must have forgotten about the cameras inside the bus that recorded everything, and after the employer supplied a copy of the video, which was reviewed extensively, we denied the claim because at no point did the employee appear to be doing what she claimed when the supposed injury happened. That is why it is so helpful to have video or strong witness evidence to help dispute or confirm any injury claim filed. We would also contact the employee Clark Kent to obtain his statement as to how the accident happened and interview him on his background. We will need to find out the nature and extent of his injuries, what the treatment plan is, and how long he is anticipated to be off work by his doctor. So, as part of our initial investigation, we contact all necessary parties, including the healthcare provider, to put them on notice of the claim and request the medical records. After all is completed, based on claim acceptance or denial, we will then make an action plan and place anticipated reserves for the known exposures. If the claim is accepted and there is another party at fault, our claim representatives are able to submit a referral to our own specialized subrogation department to work on the claim for recovery so that they can better focus on their claims handling. Just know that sometimes a claim doesn't resolve as quickly if there is a third-party insurance program for a monetary benefit to be gained, such as pain and suffering, which is not covered by workers' compensation. We also have dedicated in-house nurse case managers to assist our claim reps with collecting medical records, coordinating care, speaking with the injured worker on medical treatment and status checks, and answer medical-related questions and providing guidance to our claim reps on treatment requests. There are 3 general types of claims filed. The first is incident-only claims, which we encourage employers to report even though there is no medical treatment needed or any lost time away from work. This way, the reporting piece is done, the history gets preserved, and it doesn't affect your claims history or EMOD in any way. Just let us know if the claim needs to be opened and investigated. Then we have medical-only claims where we will process and pay any reasonable and necessary medical treatment to resolve the claimed injury. Claims also stay medical only if there is no support for disability, such as when an employee does not have a doctor's slip but chooses to stay home and recover, or if an employee with activity restrictions declines a light-duty job offer made by the employer. In addition to the medical treatment costs, this is a list of indemnity benefits which may be due and are subject to the rules and caps dependent on state jurisdiction. Temporary total disability, which is 2/3 of your employee's average weekly wage when they are completely disabled from work. Temporary partial disability for when they are working but earning less than their average weekly wage due to restrictions. For example, when the employee can return to work but at reduced hours. Rehabilitation may be necessary if an employee needs the assistance of a rehab counselor to return to work or a job placement vendor to assist with job search. An employee may also be eligible for a permanent partial disability or impairment rating, depending on the nature of the injury sustained. If an employee is so severely injured they are unable to work, they may qualify for permanent total disability benefits. If an employee unfortunately dies as a result of a work-related injury, there are death benefits available to the estate or to the employee's legal dependents, such as spouses and children. Keep in mind that work comp is primary for any bodily injury or lost time from work, and auto insurance does not pay for this, only for the property damage. But if the accident is caused by another party's fault, we can bring a claim for subrogation after the claim is over to recoup and credit some of the losses back to the claim. Investigation doesn't just stop after the initial investigation. We continually are watching the claim for unexpected development. Is medical treatment resolving the injury, or why not? Is the employee back to work, and if not, why? What can we do to address healing and, most importantly, return to work? Claims can be denied from the beginning, but also later on, maybe due to mistake of fact, or perhaps there is a partial denial issued on wage loss or medical treatment. Information seen come up on the claim may warrant collecting your employee's authorizations to release prior medical records for baseline health. We need to know, did the injury temporarily worsen a pre-existing condition? Maybe we want prior Department of Labor and Industry records to look at past work comp claims or insurance authorizations to collect information from other types of claims made in the past. We can also do background or surveillance checks on employees if we are questioning their outside activities. We want the injured workers to reach maximum medical improvement, also known as end of healing, and a release from care. Besides our own in-house nurse case managers, we have in-house physician advisors available to consult with on complicated medical treatment requests or advise on permanent partial disability ratings. We can also bring in an SFM in-house attorney to discuss the legal ramifications of a case. And ultimately, some claims come down to an independent medical exam to address if an injury has resolved, what the permanency is, and if they need any restrictions, which can be used to discontinue medical treatment or wage loss and create a dispute on benefits owed. Bringing employees back to work is a main goal in workers' compensation. Making light-duty job offers while your employee is on restrictions and still healing from the effects of an injury is key to keeping your costs down. SFM is your partner and will assist you with providing light-duty tasks and job offers to fit restrictions, which may be permanent. Again, there are rehabilitation services with associated costs that may be needed depending on how an injured worker's employment status is handled. Disputes. Sometimes a claim will generate disputes as the result of a wage loss discontinuance or denial of medical care. I had a janitor once in a school district whose injury was not resolving, and he was receiving temporary total disability benefits when we obtained surveillance video of him working as a tailor. This generated a discontinuance of wage loss benefits and treatment, which ultimately wound up in a settlement, and a much smaller one than he thought he would get. If your claim goes through litigation, your jurisdiction will dictate procedure. The majority of disputed claims will settle. Otherwise, we can take it to hearing for a judge's decision. Thank you for watching. You can find more educational work comp videos at sfmic.com/webinars.